ask is not there, save for the OB extracts.
Just don't move. And you are a lawyer. When I say I put it to you, don't respond. I've not asked any question.
Then why are you putting in the first place?
Yeah.
The question is, why are you putting in the first place?
You can put it there. You can put it all over.
Really went to law school.
So that's if you know what answers, those questions that you're putting,
I
you're
know.
putting a lot of putting in.
Yes.
Yona, we have our own label here. Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you that the OCS left the police station and the deputy was in command as an OCS.
That is not in my affidavit.
And I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has had its own. Let's go, paragraph 15. On the question of him likely to plan. You there?
Yes.
We have agreed there is no any material.
Yes, nothing
Thank you.
attached. to
Let's
this.
proceed.
Okay.
Paragraph 10.
You go back.
Oh, I asked you paragraph
15.
15.
Yes.
I'm going to paragraph 16, sorry.
Okay.
Still no material attacked. It's either very serious material you have kept, no material attacked.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you very much. Paragraph 18.
No material attached.
No material attached. Paragraph 17.
Come on.
I've gone back because there's a question I want to ask.
Yeah, please ask.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now?
No.
Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Is that on off? Because I was there yesterday. It's not true that the scene of crime has been released to the police.
Then
Is it still a scene of crime, or it is non-operational police station?
that question is not. It's not in my affidavit.
You've run very fast. You cannot lie that is it. So you cannot. There's no material to show that.
Nothing attached, Your Honor.
Paragraph 19. You've read it?
Yes, Your Honor.
And 21, they are the same.
What's the question? No material attached.
There is no material attached.
Yes.
That is very, very critical to us. Paragraph 22. I still ask you this question about the blue code of silence.
I will refer you to the High Court decision.
Tell the court. Which this is a lawyer. He knows High Court decision.
Court of Appeal decision.
Give the court that decision.
In the Titus Ngamau case, 2020. It was a phrase coined by the judge who was dealing with that matter.
And I remind you, Cliff is the one who argued that matter.
Yes.
He'll face you over that matter.
It's okay.
He's the one who argued that matter. Cliff will deal with the blue court order. Paragraph 23. You are now providing reasons as to why you want him to be detained for 21 days. True? From paragraph 23.
Yes, Your Honor.
What is the reason you want to detain him? In paragraph 23.
That we are yet to record critical witness statements.
Very well. Is his presence required physically when you are recording statements from other people?
His detention is required so he doesn't interfere with the witnesses.
Avoid recording statement and interference are two things. Wakili,
I have responded to your question. The reason as to why I'm seeking that prayer is to have him detained so that he doesn't interfere with the witnesses.
Very well. Does he know the witnesses?
Them being police officers? The answer is yes.
Is there anything you have shown of any attempt to interfere with witnesses? Because, counsel, you know very well the authorities, the Sagari, Duat Sagari, Cliff will ask you. The questions I'm asking is to prove, have you demonstrated by material your violence?
Nothing attached.
Thank you. Important. Paragraph 24. What are you addressing?
That we are saying if released, his security is not guaranteed due to the public anger demonstrated by the case. I've just read what is in the affidavit.
Yes.
I'm saying that the gruesome murder of the deceased has elicited widespread public anger. And therefore, if released at this point, the respondent's security cannot be guaranteed.
Mr. Witty took us a lot about the case of Oscar Sudi. Heavily. Have you ever had a chance to read paragraph 32 of that decision of Professor Justice Joel Ngugi?
Not in my affidavit.
It's not in your affidavit.
Yes.
For the benefit of doubt, you are saying you want to detain him on two limbs. One, for the safety of his life. True?
Yes.
Do you have anything to show that his life is in danger?
Nothing attached.
Do you have anything to show that he is a danger to anybody of the public?
Nothing attached.
So it is an apprehension.
Yes, Your Honor.
Thank you. It is an apprehension. Lawyers swear to be court officers. It is an apprehension. And you are very aware that the National Police Service is the one mandated to provide security for everybody in this country, including the already convicted murderers. You are aware of that?
Not in my affidavit.
No. You will fail to be not understanding what I'm asking. I'm asking you this question. The duty to protect life and property falls under the police.
If you say so.
And this country is not a banana country where the rule of law has broken. So it is not right to say you are preserving his life in cell. And he pays taxes. Everybody pays taxes to be protected. And that it will be dealt with in the cases that I've talked about. Now, what other reason do you need him in cell to detain him for 21 days?
All I stated
what
in my
do you specifically want him to do?
All I have stated in my affidavit.
Is there any other reason we have not dealt with?
Everything I require, I have indicated in my affidavit.
Confirm you have his phones.
His phone.
His phone, you have it.
Yes.
And you are seeking this court. Did you have the court order to possess that phone?
I don't need a court order to possess a phone.
Do you need a court order to get access to the phone?
Yes, I do.
Where is the provision that does not allow you to have authority to possess?
It's a seizure.
Waiting, allow
Sorry, no. Yona, where is the provision that does not allow you? Surely.
Where is the
You're asking
provision?
for a provision which does not allow you. This is a negative provision, does not exist in our law. He should tell us the positive provision, and counsel can put it. He can continue putting it to him that this provision does not allow you, not the negative provision.
Maybe rephrase your question.
I'm rephrasing. You know, which has a problem is preparing for the judge. It's not a key to this matter. You need him 21 days for the sole purpose of granting access. Is it him who grants access or the court?
No, Your Honor.
Who grants?
I need the 21 days to complete my investigations.
I've asked a question specific. Do you need my client in cells for the purpose of analyzing the phone?
I need your client in custody for 21 days to complete my investigations.
I've asked a simple question. Is there any role he's required to do in forensic analysis of our phone?
I'm not an expert in forensic analysis, so I cannot say.
So, your arguments are not based on any scientific, because you never consulted a forensic expert? It is you swearing 21 days.
Yes.
And I've asked you, should the court why 21 days? Why do you need him specifically?
Your Honor, the issue is not about only phone extraction. It's not only about phone analysis.
What else?
I have said to complete my entire investigations that entail so many things. Among them, what you have stated.
And lastly, you have already attached the order in your application. Look at it. We have an order. True. Makori, this is a competent advocate and witness.
No,
I have seen an annexure here.
Can I check, yes?
I've seen an annexure there. We were given an annexure that has. Is it yours?
Yes.
Or disown it?
No, it's ours.
Very well. Let me ask you the question. You are certain you are getting
It's a draft.
these orders?
Counsel, this is a draft.
No.
It's a draft.
Which is saying, is the office of the DPP or a power that gives the orders, or is the landed court? What is the import of you drafting an order? Is it a formality that in this court already you have decided, not the court to decide? Who decides? I hope it ceases from being
I hope
the norm.
we can save time by admitting that the application was drawn by the office of the DPP. What we have annexed as an order is a draft order. It is not the first time today. Is it 18? It has been done since I was a law student at the University of Nairobi, where we do draft orders. The court can reject it. It's not binding on the court. So that we save time for counsel and his client. We
have only for good practice.
We admit.
Avoid doing the judicial work. Leave the courts to do their works.
So maybe Mr. Whitty, let's not delve so much on that. Yeah.
Yes.
I think what Mr. Whitty is saying is just practice that they have adopted from the DPP's end, which is not a good practice.
It is not good practice.
So let's leave it at that.
If I sat in that office, I wouldn't allow that. Or I was chased. Thank you very much. Let me allow Mr. Kangai to proceed. sorry, Your Honor, I said,
You said
if an advocate is not allowed to talk, I will be stoned out. Put Mr. Shadrack on board. He has just left class to come out. He was teaching till he's late on the forum.
So, Mr. Katai is Mr. Shadrack.
They will release Shadrack, they will just try to put you in order. It should be a difficult one. After Mr. Shadrack, Mr. Keto will play his legal basis. Then I'll wrap the application. I think if Umbeta and Kunjui will be making a submission on that.
Your Honor, with your permission, I will ask very few questions to my colleague, Mr. Jibril. Unlike my seniors, I am the soft one.
And I hope you are around so that you don't ask again the same questions which I have already answered.
Yes, I teach law. Just relax.
Mr. Jibrin's sentiment is valid.
Yes.
I was about to make the same commentary.
The problem is his body. Cliff, make sure he eats well.
So that we could avoid repetition.
Thank you. Mr. Jibril, I want you to confirm to the Honorable Court that indeed one person of interest in the matter surrounding the death of the late Albert Ojwang is the Deputy DIG Edward Lagat.
Please repeat the question.
I want you to confirm to the Honorable Court that the late Albert Ojwang was arrested pursuant to a complaint made by the DIG, Mr. Eliud Lagat.
Yes, Your Honor.
Thank you. You also want to confirm to the court that from your preliminary investigations, the late Albert Ojwang was arrested and put in police cell, largely due to the complaint that was made by Mr. Eliud Lagat. Is that correct?
Yes, Your Honor.
Thank you. You confirm to the court that the investigations you seek time to continue with are investigations meant to assist you to unravel the persons who should be held culpable for the death of Albert Ojwang. Is that correct?
Yes, Your Honor.
Thank you. Please inform Your Honor the name of the chairperson of the body where you are coming from.
Honor, I think we have agreed that what I'm going to answer is what is in my environment.
Please just listen.
No.
This is cross-examination.
I decline to answer that question, Your Honor. It is in public domain who is the head of IPOA.
Just respond. That is your work here.
I'm responding.
Please respond. Who is the chairperson of IPOA? That is your work.
My response is it is not in my affidavit.
Yes. JV just inform me.
No.
I mean,
Your Honor, we have agreed that I will be cross-examined on what is in this environment. The chairman of Independent Police Oversight Authority's name or his position is not in my affidavit.
But you know you come from that
Yes.
background of
Yes.
IPOA, so it's...
And the council knows who is the chair of the IPOA.
I don't please answer the question. Who is the head of the body where you hail from?
We don't have a head. IPOA does not have a
So
head.
who is the chair of the IPOA?
Yes, that should be a right question. The chair of IPOA
Answer yes.
is one Ahmed Hassan Isaac.
Thank you. Now, you confirm to Your Honor that there was a joint press conference on the 9th day of June 2025. Is that correct?
Your Honor,
No,
I'm not going to answer anything outside my affidavit.
Your Honor, if you permit me, just to also give context why I am asking this question. Your Honor, my learned senior and friend, Mr. J.V. Owiti, went to a very large extent in explaining the authority that was made by my Lord Professor Joel Ngugi in the Oscar Sudi case. Some of the parameters that were set by the Honorable Court were two. I think that is paragraph 24 of that authority. On the question about bad faith, the question about exceptional circumstances, and lastly, the balance of the quadruple rights that the court should look at. One of the items that we have a duty and responsibility to prove to you is to demonstrate to you that indeed there is an element of bad faith in the application that has been made before you. And that is why my questions are aimed at eliciting some of these facts based on the evidence that is going to present before you. So, Your Honor, I plead with humility that counsel, my colleague, I even suppose is my senior. My senior should just
No, I'm not your senior.
Kind enough to
I'm not your
respond.
senior.
So
Yes,
Mr.
it looks are
Jibril,
deceitful, but
Your Honor,
what you can answer, just answer.
Yes.
If you can't answer, you don't have to answer. Yeah? What you can answer, what
Yes.
is in your information, whatever you have in your knowledge, just answer. If you don't have,
Your Honor.
you cannot argue with the court.
No. Order. Chair. Let me say this. Let me say this for the record. No, let me say it for the record. And Your Honor, protect me.
yes,
The counsel who is on the floor asking questions should only answer.
okay.
Learned senior should stop pointing at me.
Who is this?
You will have your time to ask me questions if you require. The second, Your Honor, the second point I'm making here is that anything outside this affidavit, whether our chair
It's not within your knowledge.
it's not within my knowledge, and please stop asking me. Anything outside this, I'm not ready to answer. It's not within my knowledge, and believe. And after all, Your Honor, the application we are making is about an extension of continued detention of the suspect. It's not about what happened on the backyard.
And you know,
What
that's
you're
why-
pointing is bad faith.
Mr. Jibril, that's why he was trying to lay a basis, Mr. Shadrach Oboy.
You're just give us a minute.
So we'll take a break.
No, we don't need a break. I think just
No, we don't need a break. We don't need a break.
1 minute.
Okay, it's okay. So the court is still in session, gentlemen. The court is still in session. If you have to converse, just so well.
That is what we are doing.
It's my intention to make it work. If you ask for the chairperson, please just answer. If the system goes like so don't make us suggest that you okay. Yes, that's what they're doing.
We are not like this. Is just calm down.
So calm down. Just answer what you
Yona, thank you.
We are now. So let's just have civility and decorum.
Yes.
Yeah, we're not fighting. We want to know the truth and to assist also all parties to assist the court. So I'll allow Mr. Shadrach to proceed.
thank you. Mr. Jibril,
Yes.
counsel, please confirm to Your Honor that there was a joint press conference on the 9th day of June 2025 where the chairperson of IPOA was in the company of Mr. DIG Eliud Lagat and the Inspector General of Police and others.
I'm not aware.
You are not aware. Thank you. So you have not, Your Honor, you have no information that indeed your chairperson held a joint press conference with one of the persons who's been constantly mentioned in the death of the late Albert Ojwang. You have no information, isn't it?
Your Honor, the chair attends several press conferences.
Leave those several.
So I don't follow the chair.
Thank you.
I don't follow the chair for his press conferences.
Thank you. Now, Your Honor, that is very important. You have been very honest with the court. Now, I want to return to paragraph 27 of your affidavit. Yes, paragraph 27. You have made mention that the reason why you are inviting the court to order the pre-charge detention of the suspect before court is because you have fear that he might run away from the jurisdiction of this court, isn't it?
Yes.
Have you, in your well-elaborate affidavit, demonstrated an instance where probably he was invited, he never turned up, or you have proof that he has already booked a ticket to a certain foreign land that you have presented before court?
That is not in my affidavit.
No, you have in your
No, I'm saying
yes.
the answers that you're looking for is not in my affidavit.
No, I am asking a very straightforward question, likely to attract a yes or no.
Yes.
I am asking you again. In lieu of your paragraph 27, on the question about the temptation by the suspect to run away from the jurisdiction of this court, if allowed his liberty, have you provided before this court
No.
any material?
No.
You don't have any material?
No.
Thank you. Your Honor, that should be all for me. Thank you.
I believe we have exhausted the cross-examination.
The two. I'm actually going to take very limited time in the form of 2 minutes.
I leave it to 3. So
Then I can do 125 minutes, depending on how it's going to be.
So you go first or you go first?
Now, Mr. Jibril, I want you to remember the testimony that you've given us just a few minutes ago, where you told us that the scene of crime was processed and released to the relevant authorities. Is that still your stand?
No, it's not in my affidavit. That's my answer.
You,
yes.
You made a representation to this court and told us that the scene of crime was processed and released to the relevant authorities. Is that correct or not correct?
Now, Your Honor, the scene of crime here I'm talking
about. Is it
about.
correct or not correct?
The cells where the deceased died has been processed and released to the relevant authorities.
Thank you. Now, can you tell us the investigative steps that you have used to preserve the CCTV and the occurrence book?
The occurrence book is a digital. It's not.
It's a digital.
It's a digital. Yes, yeah.
Is it with your possession right now?
No, it cannot be.
It cannot be.
It cannot be in my possession.
Have you extracted the relevant entries on that particular day?
Yes, and attached to the affidavit.
Thank you. Now, number 2, about the CCTV, can you tell us the preservation measures that you've taken to preserve the sanctity of that CCTV footage?
Your Honor, we are a team of investigators. That aspect is being done by the forensic team.
So you can also confirm that the CCTV itself is not with the police station. It is with the forensic team.
No, what was extracted is the only DVR. But the entire, you can't carry a whole screen.
It's okay. That's what I want you to tell me.
Yes. What was extracted is only the DVR.
Yes.
Yes.
So the DVR that records the events of that fateful day is the forensics team.
Yes.
Thank you. That's all.
Good afternoon.
Good afternoon. I find you allow me to ask you just 2 questions. I want to take you to paragraph 6A. Where you have said the DPA received a complaint from the Deputy Inspector General of Police. Confirmed?
Yes, Your Honor.
Was it an oral complaint or a written complaint?
It was a letter. A formal,
letter.
yes, a letter to the DC.
Provided that letter this court?
No, it's not attached here.
It's not attached here.
Yes.
Thank you. Kindly go back again to paragraph 7, where you say the respondent was arrested and under the Langata police station, OB number 50.
Yes, yes, Your Honor.
Who booked the respondent at Langata police station?
The booking was done by myself.
It was done by yourself?
Yes.
Thank you. Are you aware of the law governing the booking of a person at the police station?
As per the IPO Act, yes.
As per the IPO Act?
Yes. And the regulations.
For instance, are you a police officer or a former police officer?
I'm not a police officer. I'm an IPO employee.
Been a police officer?
Yes, I've been a police officer.
You have been a police officer?
Yes, Your Honor.
Thank you so much. Paragraph 21. Now, paragraph 21, you're saying there are co-conspirators. Confirm?
21, yes.
Do you know the co-conspirators by name?
That is part of investigations. I cannot reveal here.
No, I'm just saying, do you know by name, not their names? Do you know them by name? Because you have said there are co-conspirators. Do you know them? Not by name.
Okay, Chief, we're asking you to name them.
Counsel, this is what I've been saying. Let me answer her. The thing is,
Let me help you with it.
yes,
Just say yes or no. Do you know the co-conspirators?
the matter is under investigations.
Yes or no?
As of now, no.
You don't know them. Thank you so much. Number 25. You have said that there was the murder of the deceased was planned, executed, and their attempts to cover up. Do you know the people who are trying to cover up the death of the deceased?
One of them is your client.
Do you know that with certainty?
Yes,
Have you provided evidence to that effect?
No.
Of the attempt to cover up?
it's under investigation, but not attached to this affidavit.
You have said that, yes, you know the client is one of the people trying to cover up. My question is, have you provided evidence that he is one of the people who is trying to cover
As of
up?
now, no.
No.
Yes.
Thank you so much. Thank you, Honor. That is the
I think, Your Honor, that will be the end of the examination of the witness. We will lay now, once he is discharged, his Keaton will lay the basis for our next line of approach.
Even we would like a few minutes of re-exam because that follows cross-examination.
So,
Mr. Jibril,
Yes, Your Honor.
my work is to calm you down completely. and make you
No,
smile.
actually, I'm calm and composed.
I'm glad. Thank you. Now, I will limit my questions back to the contents of your affidavit, many times by paraphrasing.
Okay.
What is the basis of your request for detention continuing today in one line?
To complete my investigations.
On a scale of 0 to 100%, how much could you, by approximation, attach to your investigations up to now on a scale of 0 to 100%? It doesn't have to be accurate, approximation.
49%.
49%. So I can mathematically say this as direct evidence that you're saying there is 51% of investigations to be done.
Yes, Your Honor.
So that there are questions about who is in charge of the cells, who is in command of the station. Do those questions relate to the remainder of your investigations?
Yes, they do.
Now, to ask another direct question, are the questions from the defense some of the things you need to investigate to complete your investigations?
Yes, Your Honor.
Thank you very much, Your Honor. I'll hand over to Mr. Jackson.
Just one question in the examination. You have been asked whether you have attached any document relating to, I think it was paragraph 6A, some paragraphs in your affidavit, whether you have attached anything to show that even the respondent is a flight risk. Why do you need the respondent in custody? Is there any reason why you have not attached?
Yes, Your Honor. The reason I have not attached what I've collected so far, the 49% I'm talking about, is that it will jeopardize the investigations. And this is actually to protect the integrity of the investigations. That's why we cannot divulge much.
Thank you very much. I believe that is all from my end.
so thank you, Mr. Jibril.
Thank you, Your Honor.
I'm glad that you confirmed that you are calm.
Yes.
And I thank you.
And allow the next phase of our team, led by Peter. Now we proceed on check out ammunition.
We can proceed. It depends how you take
As we are ready, we are only asking for the benefit of
how many will be submitting.
4.
Starting with
There's Kiton, there's Langat, there's Tutsi.
You okay with that, Mr. Kipani? Or you need some break?
We are fine.
Proceed.
The only thing that we'll be asking is there something that has been filed so that it can be served, or it's an oral.
Let's see what they will have.
Yes, very well.
If there's anything you need done.
We'll serve you with authorities, simply. Our team serve the state with the
So I'll just urge brevity, because this issue is argued in separately. So just brevity, just direct to the point here. Submissions there.
Your Honor, for the record, I remain Felix Keaton. And also, there's also another additional attorney at law, Vincent Yegon, also is part of the defense team.
Present, Your Honor.
Your Honor, we reiterate that we vehemently oppose the motion application dated the 16th of June 2025. And from this motion, Your Honor, there is only one salient issue for determination. That is whether there are compelling reasons for pre-plea, pre-trial, or pre-charge detention has been settled in law, is well settled in law. And as such, Your Honor, Article 49(1)H and 49(1)G of the Constitution is very clear that an arrested person has a right to be released on bond or bail unless there are compelling reasons. Your Honor, in order to conceptualize and also problematize the issue, Your Honor, permit me to refer you to the statute, which is section 36A of the CPC, of the Criminal Procedure Code. And in order also to contextualize the issue, Your Honor, is that this section 36A was an amendment following the locus classicus in Michael Rotich, that is in Michael Rotich versus the Republic, the 2016 decision, whereby, Your Honor, in this section, it lays the two-tier threshold for such an application to succeed. The first burden, Your Honor, is on the investigation, that is the IPOA. And the other also burden also, Your Honor, rests with the Honorable Court. And as such, Your Honor, under Section 36A, it is very clear that pursuant to Article 49(1)F and G of the Constitution, a police officer shall present a person who has been arrested in court within 24 hours after being arrested. And now it lays now what the investigation officer must do. First, he must make an application in writing. First, he must produce the suspect in court, which they have done, which we admit that. Then the second thing, Your Honor, is that they must apply in writing. And they have done that through this motion application. But now, Your Honor, the greatest issue that they must also do, Your Honor, is that under Section 36A, Clause clause 3D. It states that the investigation must also adduce the reasons necessitating the continued holding of the suspect in custody. So the question that begs our attention at this juncture, Your Honor, is whether there are reasons necessitating the continued detention of the respondent. And we submit, Your Honor, in negative, that the investigations have not adduced any cogent reasons necessitating continued detention of the respondent. And Your Honor, my learned friend, they have already gone through the cross-examination limb by limb in the entire affidavit. But if you may permit me only to refer you to 2 or 3 salient issues, Your Honor, in order to illuminate why this motion application is bereft of meat and substance to stand on. First, Your Honor, I will refer you, Your Honor, to look at paragraphs 9, 10, 11, and 20 of the affidavit. They are building a case that you should continue detaining the respondent because he is likely to interfere with the investigation. We submit, Your Honor, that that is not a cogent reason. And we'll invite you, Your Honor, to consider the authority which we have provided, that is Republic versus Mercy Chebet. It is a 2022 decision whereby Justice Gigonyo has indicated succinctly, and I'll humbly refer you, Your Honor, to paragraphs 17, 18, and 19 of that decision, whereby the High Court has settled the law that for such a threshold to succeed, the investigation must tender material information to the Honorable Court to demonstrate the nexus link that is between the respondent and the likelihood of interference. And I will also refer you, Your Honor, to also adopt the reasoning of Justice Mutuku in Republic versus William Chichiri and Godfrey Kirui, whereby the same threshold.
Your Honor, this is not an objection. It's an humble plea that counsel shares the decision with us, and that it is generous enough that he also points out the paragraph that is paraphrasing, so that we are able to respond there.
Your Honor, we have already filed our list and digest of authorities dated in 16th of June 2025, and you can confirm, Your Honor, that they are there. The decisions and everything we have already finished. It's the last decision. The last one. Cancel the one which is on the. There is the one.
Sorry. I am looking at your document, sir. I am alert.
Thank you.
The document written respondents list and digest of authorities.
Yes, Your Honor.
I am looking for Mercy Chebet. You have it in the list.
There is another one which is look.
So it's not in the list.
No, it is in. Is the one you are holding.
Thank you.
No,
this is the list. It does not have Mercy Chebet. Does it have it?
You already have an authority, the one next to your phone.
You know what we are informing the court is that we didn't have it in the list. So if he has added it, that's okay. That's what you're asking.
So
we can have the
authority, Honor. You have already defined it.
Because for myself, you've supplied.
Yes.
And I think I'm comfortable.
Yes.
I have the Mercy Chebet.
Yes.
And but I don't have the William one. William
Yes.
Yes.
Yes. So Your Honor, if I may.
Did you file for the William?
It appears there was an oversight, Your Honor, but I know the court takes judicial notice of all the citation, of all the authorities which we have already provided the citation, Your Honor. Sorry, Your Honor, he has interfered with the flow of my thoughts.
My apologies. My apologies. I am not in that business like my colleagues.
Yes.
The two that must
So what you are saying, Your Honor, at paragraph 17, Justice Gigonyo has laid the threshold and also illuminated that interference with witness undermines the criminal justice system and dents the integrity of the criminal process. And he goes on and also says that for such a ground to succeed, the prosecution must tender or must present material information to the Honorable Court. And the earliest decision which we have also cited, Your Honor, the William Chirchir case, whereby Justice also Mutuku has said that there should be a nexus between the respondent and also the stated interference, Your Honor. So that was the main ground, Your Honor, that has been advanced at paragraphs 9, 10, 11, and 20 of the affidavit. Another link, Your Honor, of the affidavit is that, Your Honor, I will humbly beg to refer you to paragraph 24 of the affidavit, whereby you have been told, Your Honor, that the gruesome murder of the deceased has elicited widespread public anger and outrage leading to demonstrations which at times have been destructive. Hence, the safety and security of the respondent cannot be at this point be guaranteed if released on bail. So in order, Your Honor, to demonstrate that such a reason, Your Honor, should not hold waters is that we will humbly beg to refer you to the same decision of Justice Gigonyo, that is Republic versus Mercy Chebet, whereby at paragraph 20, which is also titled Safety and Security of the Accused Person, the judge lamented, Your Honor, at paragraph 21, that I have lamented time without number, and again slide into grief. How and why in this age and time should people take the law into their hands to harm the accused? The community herein is within the territorial jurisdiction of the Republic of Kenya, a nation governed by law and order. And under the Constitution of Kenya 2010, I wonder whether the said community will derive the authority to harm or kill a suspect under trial. No one is above the law or should take the law in their hands. All are bound by the Constitution which reigns. And the community in question should let the law punish the accused. This should stop, and my view is that ground that the security of the accused is threatened by the members of the public or victim family should never, and mark my words, Your Honor, should never be encouraged to be a ground for denial of bail. Otherwise, the courts will inadvertently promote or condone violence, disorder, and usurping of law by individuals or group of people. We say no more, Your Honor. Such ground should fail in limine. The court, the High Court, has settled the law on that. On the other hand, it is even the duty of the police to also guarantee the safety of the respondent. And you have also been told other issues, Your Honor, that they need time to do forensic, to subject the grudges to forensic, etc., etc., etc. We submit, Your Honor, that all those reasons that have been given, it can be done without the need for any custodial order. So we submit, Your Honor, that from all the reasons that have been adduced, none is cogent and none should pass the master of the law, because they have already done what they ought to have done, and any proposed investigations can be done without the need of subjecting the respondent to custody, Your Honor. Having submitted the limb, Your Honor, that they have failed to demonstrate the reasons necessitating further or continued detention of the respondent, Your Honor, we submit on the second limb, whereby their statute also, Your Honor, has also given the court the latitude or guidance on what should do. And we shall invite you, Your Honor, to consider Section 36, Clause 5 of the Criminal Procedure Code, whereby it is stated that a court shall not make an order for the remand in custody of a suspect under subsection 5 unless there are compelling reasons for believing that the suspect shall not appear for trial may interfere with witnesses or the conduct of investigations or commit an offense while on release. So, Your Honor, even having submitted that they have not adduced that reason, there is a duty that the court also must also satisfy itself before granting any custodial order, that there are compelling reasons that the suspect will not appear during the trial. And there is no such reason that has been advanced by the state, Your Honor. And the other aspect of interference, Your Honor, we have already submitted that there are no material information to persuade you that there is a need to further detain the respondent, Your Honor. And in doing so, Your Honor, on the duty imposed on the court in the two-tier threshold, that is the threshold in the second tier threshold, which is the duty of the court, will invite you, Your Honor, to adopt the reasoning of Justice B.J. Otieno. That is a High Court decision in Ramadan M. Hassan versus DPP. It's a 2017 decision, whereby at paragraph 15 of that decision, Your Honor, it is at pages, you are finding that authority. It's at pages 43 to 46 of our bundle, whereby the judge reasons this way, Your Honor, that I must add that a judicial officer before whom an application is presented seeking to limit the enjoyment of a suspect's fundamental freedom akin to the right to liberty is duty bound and enjoined by law and the Constitution to be extra vigilant and not to interrogate whether the facts presented to it melt the dictate and spirit of the law invoked before it and are in consonance with the attributes and general philosophy of the Constitution, which guards against arbitrary and unjustifiable limitation or enjoyment of rights and fundamental freedoms. So Your Honor, will humbly persuade you to adopt that reasoning to be extra vigilant in granting such an application, Your Honor, because this being a temple of justice, Your Honor, you hold that mighty sword of Damosil, and you should always strike for the rule of law and nothing else. So having demonstrated, Your Honor, the two-tier threshold, that it fails in every limb, we conversely, inversely submit, Your Honor, that on the other hand, there are compelling reasons to release the respondent on bond and or bail. And we'll humbly invite you, Your Honor, to consider certain factors. Number one, Your Honor, is that the respondent before you cooperated with investigation. I accompanied him, Your Honor, on the 11th of June, 2025, when he was summoned by the Independent Policing Oversight Authority to record a statement under inquiry. And he did so, Your Honor, and he was released. Thereafter, Your Honor, he also presented himself to the DCI Gigiri headquarters on 13th of June 2025, whereby, Your Honor, he sought assistance to be escorted to the IPO offices to seek whether he is required there or not. And indeed, in my company, he was escorted, Your Honor, and he presented himself, and he cooperated, and he agreed even, and he was duly booked at Langata Police Station, Your Honor. So he has already cooperated, Your Honor. That is a factor which you should consider in granting him, Your Honor. The other factor which we invite you to consider, Your Honor, is that there is already issued in place an interdiction letter, which is duly signed by the National Police Service. And Your Honor, in order to put into perspective, an interdiction letter, Your Honor, is a sua generis document which sets certain conditions, which is replica of the conditions imposed under Section 36A of the CPC, and also, Your Honor, which technically it holds in abeyance the powers of a police officer. In other words, Your Honor, it removes the thief from him. He can't do anything. And from that interdiction letter, Your Honor, which I had a privilege of seeing as an attorney at law, Your Honor, he has been told categorically that he should report to the OCS, to the Eldoret Police Station. So there is also a condition, Your Honor, to demonstrate that it's not a flight risk. There are already safety mechanisms which have been imposed by that interdiction letter, Your Honor. We'll also invite you, Your Honor, to consider the primary consideration of bond and bail. That is to secure the release of an arrested person as and when required. And irrespective of the issues, Your Honor, whether there will be any intended charges or anything, he is still an arrested person within the meaning of Article 49 of the Constitution. And as such, the rights under Article 49 has been activated. And such rights, Your Honor, should be enjoyed to the greatest extent possible. And in interpreting, Your Honor, and in contextualizing the situation, Your Honor, we will humbly persuade you to adopt a latitude that is beneficial to the suspect rather than the state. And in doing so, Your Honor, we will humbly invite you to adopt the philosophy of in Justice Kimaru, as he then was, in Michael Rotich versus Republic, whereby, Your Honor, it's an authority from pages 22 to 26. Whereby the judge here, at least in this decision, Your Honor, conceptualized and also reiterated the importance of liberty being in pressures that are personal liberty. Right to liberty should be respected at all times unless there are legal reasons for such person to be deprived of his liberty. And the police should only arrest a person when they have a prima facie evidence that an offense has been disclosed which can result in such a person being charged with a disclosed offense. Your Honor, the reason why we are citing this decision for avoidance of doubt is to reiterate the importance of liberty. It's not about the holding charge. So even in their response, Your Honor, they should not deal with the holding charge. Reasons being, Your Honor, we had a privilege of interacting with this decision, Your Honor, when my then client, Major Rotich, may his Lord rest in peace, was arrested, and we went all the way to High Court. And the court made certain findings, Your Honor, including one holding charge and this liberty. But the holding charge question, Your Honor, has already been, there is a mutation of law. So that is no longer applicable, Your Honor, and we shall demonstrate the reason why that decision is no longer, the question of holding charge is not applicable, is because of the second decision, which we have also furnished you, that is in Kenneth Omondi, Ocheng, and 38 others, whereby the same judge also reiterated and illuminated the law, knowing that there was a development, because between that Michael Rotich and this Kenneth Omondi decision, Your Honor, there was an amendment to Section 36A of the CPC, so which drastically changed the law. That's why we will also adopt the reasoning of the judge that the reason why this court in the Michael Rotich case required a charge or a holding charge or provisional charge to be presented to the court when the prosecution is seeking extension of time was first to inform the arrested person of the likely charge that he or she may face, and secondly to inform the court on the serious nature or otherwise of the charge. So that was the reason in that development of the jurisprudence, Your Honor. So in grounding our application, Your Honor, and also we'll also invite you to consider another factor, Your Honor, that the suspect before you, the respondent before you, is still presumed innocent. That is verse 1 to Article 49, I think 1A, 52A of the Constitution, whereby he is presumed innocent unless otherwise proven. So no matter the veracity, the public pressure or anything, Your Honor, he is still presumed innocent. So we'll also invite you to consider that one, Your Honor. And finally, also we'll also invite you, Your Honor, to consider that is not a flight risk. Yes, fixed aboard, both within Nairobi and also in Eldoret. And it has not even been demonstrated also that is a flight risk. So those are the issues, Your Honor, that we'll humbly invite you to consider in granting him bond or bail, Your Honor. And we'll humbly beg to ground our application on that under paragraph 3 to 5 of the bail and bond policy guidelines, which will guide you, especially on the situational analysis. And we'll also beg to ground our application also, Your Honor, and to support the same also, as per the decisions which we have cited, which we have already provided. That is the authorities, especially the Court of Appeal in Jayendra Jimji Malde versus Republic, whereby the Court of Appeal settled the issue and reiterated the procedural provision that an arrested person has a right to be released on bond or bail unless there are reasonable reasons not to be released. And also the Court of Appeal has also reiterated that now, unlike in the past, even those persons charged with serious offences such as murder are entitled to bail on reasonable conditions. And the applicant here is certainly entitled to that bond, Your Honor. And also on that other issues also, Your Honor, which you have been told that there are compelling reasons, except the question of interferences, safety and interest, Your Honor. We'll also humbly invite you, Your Honor, to adopt the reasoning of Justice Mativo in Republic versus Danfo Kabage, and I know my learned senior Cleveland Better also argued that matter, whereby the High Court has laid the test of compelling reasons. That compelling reasons or grounds ought to be proven to the satisfaction of the court. And mere allegations or possibility is not enough. And bail cannot be refused simply because the accused has been charged with a very serious offense. And that the burden of proving such to the court that there is one or more grounds rests solely with the prosecution, and there is no time whereby the burden can shift to the respondent, Your Honor. We'll also rely on the other decisions which we have tendered, Your Honor, the Betty Timotai Kimeyua case, which was also a reaction to the Michael Rotich case before the amendment, and we have already furnished to you, Your Honor. And as such, Your Honor, will invite you to decline the application before you because the same is bereft of meat and substance to stand on, and to invite you to unleash your sword of Damocles and to strike for the rule of law and to admit the respondent to bond or bail. And will humbly, Your Honor, suggest that he be released on cash bail or 7,000 shillings. That is what he can afford, because we also know the conditions of the officers in the Republic of Kenya. And also, Your Honor, in also making your ruling, Your Honor, will humbly invite also you, Your Honor, to make certain policy or in your dictum to find or to make certain policy considerations. Because the reason why we are here, Your Honor, is also because of the legal edifice of IPOA, which is created under the Independent Policing Oversight Authority Act, number 11 of 2011. Whereby, Your Honor, I wish, as the people of the Republic of Kenya, we had constitutionalized or made IPOA one of the commissions or independent officers under Article 248 of the Constitution. It would be good. But what the Parliament did in that Act, Your Honor...
Sorry, Your Honor. Sorry. You know, Mr. Keaton is a good friend. He has like a law teacher, like my friend Shadrach Wangui. What he's inviting to court to do, which is now justifying, is beyond the jurisdiction of this court. You cannot make policy. So he should just save us time so that we go to what this court can do. Although he had a very good point, but this court has nothing to do with it.
It was just an dictum observations, Your Honor. And the reason why they do that one, they know is that in what the IPOA Act, what the parliamentarians did was to establish a weird...
Your Honor, we have objected to that time.
It's okay, Your Honor.
This court has no jurisdiction.
I withdraw, Your Honor, and we humbly beg to submit, and I beg to rest my submissions and raise their questions for me.
Okay, thank you.
Thank you.
I've really appreciated your industry you've put in.
Thank you, Your Honor.
You've argued it so eloquently.
Thank you, Your Honor.
And eruditely.
Thank you, Your Honor.
So I believe the others will not have anything to say. Mr. Langat.
It is Langat. Good afternoon, Your Honor.
Okay.
I'll only go straight to what my colleagues on the other side submitted earlier in the opening statement, and more specifically on the case of Sudi Oscar Kipchumba versus the Republic. The decision which I believe they will share with you, I've just looked at it and analyzed while sitting here. These are decisions that, in essence, will allow you to dismiss the application today. I'm happy because they are the ones who brought this decision. It's a very beautifully done judgment, ruling. The tests that they have been argued by my colleague under Article 49 are found in this ruling. I want to address one or two issues first one is the aspect of the investigations. They have made a picture, or they have painted a picture that our client is likely to interfere with investigations. Your Honor, today, the witness, in his affidavit, and while being questioned in examination in chief and in re-exam, has told this court that they are in control of certain important exhibits which are not within reach of our clients. There's no way you can interfere with those items, exhibits, which are in control of IPOA. Your Honor, the second aspect, which I believe will be addressed by my learned seniors, is the aspect which came out in the affidavit, the issue of forensic analysis. The forensic analysis of the phone, the gadgets, will be done and shall be done in the absence of our clients. IPOA has officers capable of doing that job conclusively without any input from our clients. The attempt by the applicants to say that our client should be in custody while this process is going on should not be entertained by this court. This court, Your Honor, should abide by the binding decision in Professor Ngugi's decision and release our clients on reasonable bail, which my colleagues have suggested, and put even other conditions which our client is willing and ready to abide by. Those conditions, the discretion is with the court. We therefore submit that the application has fallen short of meeting the threshold set by various decisions cited by my colleague and have been supplied to the court, meeting the requirements of compelling reasons. Finally, Your Honor, the affidavit that was filed before this court does not produce, does not even have did not even attempt to convince you for those compelling reasons. With that, Your Honor, I beg rest my case. I'll allow my seniors to have their time. Thank you.
You know, with the greatest of brevity.
Yes.
Kanahi, Your Honor, whereas my good colleagues have cross-examined the veracity of the affidavit at the point, my good colleague, what to call him Dr. Kiton, has laid the legal basis, the premise upon which creates a question with the application before you. I'm just reminded before my good colleague, Mr. Ambeta, submits its finality to say that the application notice of motion that is before you seeks in prayer A, B, C, D. One, that the matter be had inter partes, which is what is happening right now. It is seeking in prayer B, that the respondent be remanded for 21 days, pending completion of investigations. It prays in prayer C, that the electronic gadget seized from the respondent be subjected to forensic examination. And finally, any further orders that this honorable court may deem fit. I am certain, and it's a position we take, that we have no objection to prayer C. If the so would want to examine the gadget, given the fact that they are already seized and in custody of the gadget, as to whether we oppose or not, we would not control what they intend. Principally, what Your Honor is being called upon is to give a continuation of detention of 21 days to complete investigations. We submit, Your Honor, that in the deposition of my good friend, Mr. Jibril, that he has since the last 7 days covered 49% of the would-be investigation, I doubt that he would need 21 days to complete the remainder of the 51% of the investigation. Why am I saying this? The persuasion of my good colleagues that, Your Honor, be minded of the provisions of Section 123 of the Criminal Procedure Code, read with Article 49(1)H, as well as G of the Constitution of Kenya, in matters bail, that you be inclined to admit the respondent to a pre-plea bond condition is the positive aspect that we are all taking, and we have no doubt that Your Honor, clothed with white powers to make such a determined decision on bail bond, would grant. But in the unlikely event that Your Honor is disinclined to grant bail bond as is being prayed, that you consider that the days so requested for 21 days are days which are more than sufficient for them to rely on. We are saying that the custodial detention should not act as a punishment. Given the fact that you've been told the cooperativeness of the respondent and the clear position of the application before you, as well as the affidavit of one Mr. Jibril, which presents before you no evidence that the respondent is a flight risk, no material evidence, as said, is placed before you that the respondent is likely to interfere with any witnesses or investigations as they are ongoing. But most importantly, that their wish to have the respondent not granted bail is premised on his own safety. And we would only ask, is the police saying that they are unable to secure and safeguard the safety and interest of its citizens? In the threshold of that, Your Honor, we plead, like my colleagues have pleaded, that to be inclined to grant the respondent bail bond pending this investigation, and I'm minded that he has been cooperative and no indicator has been placed by the investigators or by way of affidavit that he is likely to become uncooperative moving on forward in this particular investigation. And should in both lean as to whether you grant bail, which we hope you do not, that the days sought for completion of investigation are in excess, Your Honor, and that if they are limited, it would not in any way prejudice the investigations, as nothing would bar the good investigators from making a return to this court and seek extension of more or further time so to conclude the investigation. As we oppose that application, we plead with Your Honor that you admit the respondent to bail bond pending this investigation, and in the event of such disinclinement, Your Honor, be considerate to reduce the number of days that the applicant seeks to hold the respondent in custody. Finally, we submit, Your Honor.
Okay, Your Honor, I was thinking that my colleague Shadrach was going to say something. But Let me start with if whatever wants to add, you can add. But
The last one submits to
yes.
finality.
Okay. Now, Your Honor, let me start first of all by asking that let me request that the court, first of all, Your Honor, grants bail to the accused. I mean to the respondent to this matter. Please grant me. And I'll be requesting the court very humbly to do so. Why am I saying this, Your Honor? It's because now I believe that once they have come under Article 49G and 49(1)H, they have an obligation to give you compelling reasons. It's an obligation. It is nothing less than that. Your Honor, if then they have failed in that particular point, what then becomes of that article? Doesn't it become absolute once they fail? And I'm saying they have failed at least miserably today. Why am I saying this, Your Honor? Because if you look at Article 49, and this one was also in the Republic versus OM of case, the court has indicated what is supposed to be a compelling reason. That's in paragraph number 23. Tushapatia mingi mkonazo mpaka tumechoka, sio? What does the court say something to do with compelling reason? And this is the Court of Appeal in the realm of the Republic case. It must be something that is forceful, something that is so convincing, something that is so strong that the court cannot ignore it. Cannot ignore it. Now, Your Honor, once we have seen that, then the state has come and told you they want the suspect or the respondent to be in custody because they want to investigate or they want to have access to his phones. What they did not tell you is that he gave them the passwords and they are keeping quiet about it. And if they want the password, we can give it here in court now, so that that point, ya kutaka simu, is out of the window. Let's finish that one. It's a simple thing, a 1-minute thing, doesn't need 21 days. They tell you that there are CCTVs that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DVI. That is the most important one. So what they have there is a shell. And that's the reason why they can't pick it. And that's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. Then they're telling you they are going to interfere with the investigations. But in his affidavit and what he has said here on oath is that, in fact, I've given you a password. Pick a password. They're telling you.
It's okay, you don't have to take it, eh?
Yes, Your Honor. The issue is not about the SIM or the password. It requires a lot of things.
Okay.
Your part is crucial. Watching me. I'm running the show.
Okay.
Yes.
Now, they are telling you about witnesses. They are not telling you the affidavit with witnesses, but they are telling you something else that is imaginary. That they are yet to get some other witnesses who they are going to record their statements. What does that show you, Your Honor?
that the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail to an accused person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of the respondent here. When the IO here called him, did he appear? Yes. When he was told to go and record a statement, did he appear? He did, and recorded a statement under inquiry. When the DCI director himself spoke and made some wild allegation in Parliament, the OCS woke up by himself and took himself to the Gigiri police station, headquarters CAT, and asked, do you need anything from me? Look at this kind of person we are talking about. Do you need anything from me? Then they arrested him. Why would you deny him bail, Your Honor, when such a person has exhibited a person who is capable to cooperate and even volunteers before they get those Subarus to go and pick him? He volunteers. So today, we are talking of a person who knows the law and respects it. Those are the grounds that they had for you today, Your Honor. So what else remains? Now let us go back to that issue of the litigation. Then have they convinced you, Your Honor? And I'm saying they have not. And that is why I will agree with my learned colleague that if you gave him a cash bill of 7K, that is fine. In fact, for me, I'd say pre-bond. Because at the time he was going to those officers, he was okay. There was no money, there was no cash bill, but he went. That shows a person willing to come to court. They quote Article 19, they quote all those articles in the law. But you see, Your Honor, today, let us agree. Why do we have these fundamental rights? It is so that we can protect this kind of person from this kind of people. The police. That is why you have these fundamental rights. And Article 19 is quite clear, and it's my favorite, that these fundamental rights, who do they belong to, Your Honor? They belong to an individual and not the state. Not the state. Once they know that those fundamental rights exist, they come to Article 20, which is very clear and says it binds all state organs, including the court, including the prosecution, and including the officers, the police officers. That includes also IPO. If it includes them, today they come with an affidavit and tell you, denying bond on very flimsy grounds. Did they read Article 21? I am certain that they ignored it because Mr. Whitty, my friend here, would have told them. And I don't know why he's not telling them, but Article 21 is clear that when these fundamental rights are known to exist, all these arms that I have mentioned, what are they supposed to do, Your Honor? They must start by wanting to grant this fundamental right. Article 20, sub-article. Might start by wanting to grant to ensure that this person enjoys the fundamental right. But they still give you this affidavit. So what do we do, Your Honor? Article 22 is clear. Once we have noted that they are in a position where they want to prevent an enjoyment of these fundamental rights, we come under Article 23 and Article 165. Very clear articles. So that the court, once it has noted this kind of, can I call it, bad faith application, will be able to see. Let me qualify it to say, why does it come under bad faith?
have an IO who has come to court today. What does the IO do? Refuses to answer questions. Just he will not answer that. He will not say anything. He doesn't know anything. He doesn't even know who his boss is. And he doesn't know whether he attended a press conference. Now, things that are in public domain, and we know them by ourselves. Why should you believe him today? That once you release this person to him, he shall be treated well. Why? You cannot believe him because he denies publicly even his own boss. I know now how Jesus felt when Peter just and then, Your Honor, if that is the position, and then they come and tell you, oh, this the public order and issues like that, and that the safety of this person depends on them keeping him in custody. Where does that come from? Because Article 29 is clear. This gentleman must enjoy his fundamental rights. The security, it is provided by the state. It is guaranteed. Guaranteed. So they can't come here by a mere application and tell you